G'day friends and foes, Arjay here with Arjay's TINLA, or This Is Not Legal Advice, and nor is it. So this is episode 66, and it is a quick update, maybe 5 minutes, 10 minutes long, and basically I'm saying about what's happening with some more protests and another court action. So basically, last week or so, I put in for more protests in Kawara Park. A lot of you have seen videos from Kawara Beach that I've done over the past couple of weeks. And I put in for 500 to 5,000 participants. And obviously that is a lot more than the current 30 people mass gathering limit in Queensland. But basically, I am running for election for the seat of Surfers Paradise. I need to get my name out there, of course, and obviously that's why I need to do a big rally. And basically, with the big rally, I have it for I think it's the 4th, and then a week later, and a week later, and possibly... then it would be the election already. So I put in for multiple days, as I said, 500 to 5,000 people at a protest / political rally. So again, protesting the illegal, unlawful, ridiculous COVID directions, including, the lockdown, the banning of medicine for COVID-19, such as hydroxychloroquine, where doctors can get a $13,000 fine and jail time for prescribing it for that purpose, as an example. And anyway, so I have put those in as authorised protests. They have been opposed by the police. They originally were not going to oppose them, but limit it to 30 people. And I did already put in, maybe a couple of weeks ago for further COVID restriction exemptions again. And again, they've just been ignored by the Chief Medical Officer, Dr. Jeanette Young, or Chief Health Officer, same difference. And anyway, so the police, when they oppose them, I suggested that the police make sure that, one, that there is a proper mediation, not just someone calling me and telling me, you can't do it. That's not a real mediation. And two, that the case is put in the name of the Police Commissioner as per the Peaceful Assembly Act, 1992, Queensland. And anyway, so they were looking at doing the latter, but then said that they weren't going to do a mediation, that them calling me on the phone multiple times was a mediation, as confirmed by QPS legal team. So the QPS is the Queensland Police Service. They have their own legal people, and they incorrectly advised the acting senior sergeant that mediation is him speaking to me on the phone. I then wrote him back an email suggesting that if he doesn't want to commit fraud or perjury by putting on the court application that the required and legally required mediation has taken place, that I have contacted, I think it was 3 different mediators, just via SMS, asking, hey, look, is it possible for you to do a quick mediation for free between myself and the police in order to give standing or jurisdiction to the court to hear a matter involving COVID directions? Because obviously I've been opposed on COVID grounds, and therefore I have standing to challenge that, because if the COVID grounds are bumpkus, or bupkus, whatever you want to call it, like fake, then obviously they can't ban the protest based on that. And also a part of the acting senior sergeant's, negotiation was saying, hey, don't do it next weekend because there's a market there, do it the weekend after. And then, as I pointed out, hey, look, there's only a few weeks until the election, and it's actually good that there's a market at Kawara Beach or Kawara Park, because that way more people can see the thing. So with such a big protest, if it was approved, then I was going to arrange some, good speakers and make it a bit interesting. But for the 4th, because, we've still got to go to court and whatever, I won't basically mess some people around, because otherwise I book them in and, some people might well travel and then not be able to do the protest or have it limited to 30 people. There's no point getting a bunch of really great speakers, interesting people for 30 people going. So presumably on the 11th, by then it'll be sorted out. So that'll be like the first big one, if it can go ahead. And anyway, so then the acting senior sergeant has contacted me saying that he had further correspondence with the Queensland Police Service legal team, and obviously it seems that he sent my email to them saying, hey, look, what the hell, Mr. Martin suggesting that it would be perjury or fraud if I stated that there was a mediation without there being, an independent mediator, blah, blah, blah. And anyway, they are going to do a mediation tomorrow. So if that fails, then it goes to the magistrate's court, and the court will have standing to hear the matter. And hopefully it's not like the previous magistrate, or it might be the same magistrate, but hopefully it's not like the one on the 29th of May, when the magistrate didn't allow me to even speak, basically, let alone make submissions. And I do finally have a copy of that transcript and the decision part of the transcript as well, from Ausscript, who does the, Queensland courts as well as some federal courts. They do like the audio and transcripts for court cases. So I might act that out somehow. I was thinking of doing like a little puppet show, or, since I have those augmented reality emojis, sometimes you see me with like a cartoon head or as a fully cartoon person, that I can act out that magistrate's court decision, and you can judge for yourself if you think it was a fair hearing. And just I'll quickly explain, natural justice includes the fair hearing rule and the no bias rule. And again, when I do that, you can judge for yourself. And with the actual original case, the Supreme Court has a filing, as I've filed an appeal to the Supreme Court, which is file number CA10191 from the top of my head. And I'll also do a video on the questions of law that I've put with that. I have covered in another video, even though it's quite, too detailed probably, it goes for about an hour long, some of the remedies sought, such as declarations that certain provisions of the Public Health Act are invalid, that the COVID directions are invalid, that they are incompatible with human rights, that the original decision in the magistrates court and district court get quashed, damages for loss of rights, etc., and declarations and injunctions, writ of prohibition or writ in the nature of prohibition against mandatory vaccination. If you don't think, as ScoMo said, the vaccines will be as mandatory as possible, then I suggest you may well be mistaken. And that's for the experimental COVID vaccine. The AstraZeneca Oxford University one involves a genetically modified chimpanzee adenovirus, or adenovirus, however you want to pronounce it. So basically, with the common cold, there's three main viruses involved. One is coronavirus, one is rhinovirus, rhino meaning nose, of course, and the other one is an adenovirus. And anyway, so they've genetically modified an adenovirus to have Chinese horseshoe bat protein spikes to match the SARS COVID virus number 2, or whichever way you want to call it, the thing that's supposed to cause COVID disease. And then it goes in your body and replicates and has your own cells producing genetically modified monkey virus. Technically a chimpanzee is an ape, but same difference. So besides the tail maybe and walking upright, blah blah blah. So anyway, that'll be interesting to see what happens at the mediation tomorrow. I assume, even though going into it with good faith, but I assume that it is not likely to result in a resolution, because obviously the police are bound, they believe, to the Chief Health Officer's COVID directions. The Chief Health Officer has not bothered approving nor banning or saying yes or no to my COVID exemption, which you can apply for just on the Queensland Public Health website. And then if that's not successful, then it goes to court. And then it doesn't have the issue of a threshold issue or an issue of standing, if you want to call it that. So the matter can proceed in the court, because otherwise I would have had two options. One would be to pretend that, i.e. ignore that there was no required mediation, but then obviously they would use that in the main court case to try and claim that there was, acquiescence or whatever, and that's beside the point anyway, because the Act says there must be that mediation. Or the alternative would be that it's a wasted court case, because I just have to say, with respect, Your Honour, there has not been the required mediation, because, there was no mediation. There was no mediator who was a mediator, etc. But then obviously I wouldn't be able to submit the actual substantive parts of the case, i.e., COVID directions aren't even law. They have not been gazetted in accordance with Queensland law, nor the common law. But anyway, so I'll just bugger off now, and please like, share, subscribe, donate some money if you really like. I do have a COVID court case GoFundMe, which obviously the money can only be spent on the case in question, as in the now Supreme Court case, including if I lose, so that I don't have to pay all of the costs myself, but also, there's filing fees and disbursements. There may be some expert witnesses, that kind of thing. And even though the case is already submitted to the Supreme Court, it won't actually be heard until, I think it was sometime between the 8th of February and the end of March. But perhaps a magistrate this week, if it does go to court, might well knock COVID directions in Queensland on the head, so therefore it can be used in other states as well, and territories, obviously, as persuasive but not binding precedent, depending on which way you want to look at it. There was a High Court case many years ago called Farrer Constructions that actually suggested that Supreme Court decisions in one state apply to another state as actual binding precedent. So it may well have been only if it's at the Court of Appeal level, as opposed to a single judge. Mine is at the Court of Appeal level, and it may well be the case that my case is actually removed to the High Court, and therefore it's decided for all of Australia. And obviously the case can then be broadened, so it's not just specifically Queensland law, but Victorian and everyone else's law. because obviously if it's illegal in one state or territory, then it's illegal in all of them, in terms of if it's unconstitutional, as an example. Anyway, thank you. Bye. Ooh. It's just been out delivering flyers. Here's my little flyer. Get one that's not half scrumpled. Whee. Like a little wanted poster. Anyway, cheerio.